everybody. Thank you all very much for being here. I'm Shannon Joseph. I'm the chair of the Wake County Bar Association CLE Committee. And as you know, today we have a program for you that are the tips from our Superior Court judges about how to improve your Superior Court practice. Playing the role of Judge Howdy Manning today will be Judge Donald Stevens. We also have Judge... Sorry about that, Judge Stevens. We also have with us today Judge Ripley Rand, and as may be his preference, Judge Carl Fox will be making a dramatic appearance shortly.
We have this tradition in the office called the return of the howdy. Whenever Judge Manning comes back from holding court somewhere else, he always gathers the staff together to tell them about his week. We call it the return of the howdy. So usually you can see the staff scatter every time he comes into the building after his return. I could not begin to replace Judge Manning, and I cannot bring you up to date on Leandro. If you came to hear that, you're in the wrong place. We have some extra seats in here. Up here if anybody wants to come have a seat. I asked Shannon and Ripley if I could just make some general remarks, since I was told yesterday that I would be participating in this program and didn't really participate in putting together the 10 things to be discussed. I'd kind of like to talk to you just about the sort of ramblings of a trial judge for a few minutes to set the stage for this, and hopefully Carl will be here by then. A lot of you here are older than I am and have practiced law longer, and some of you have not. I was licensed in 1970, about 36 years ago. I picked my first jury in the Superior Court of Durham County in 1975. 30 years ago, the citizens of our counties enjoyed and appreciated, I think, and were sometimes honored to be summoned for jury duty. We could pick a jury in an hour or two, and seldom did it take more than a week to try a case. Our population has moved fast forward. We've gotten into the me first society, and frankly today, very few people summoned for jury duty have that same kind of attitude. As a trial lawyer, you need to understand that. Our response to jury summonses is about 40%. Citizens frequently resent being summoned for jury duty. If you waste their time, they will punish you. If you are unprepared, unfair, take stupid positions, or a jerk, make too much of a demand, they will react appropriately. You need to keep that in mind. It's a different day and a different time. You need to understand that jurors do not view this as a privilege for you to have the opportunity to try a case in front of them. They treat it a little differently. They look at you a little differently. I suggest you should be perhaps a little more diplomatic in how you treat the jury. You should be more gracious and appreciative of jurors and their service. And obviously, if you are professional and efficient, they will treat you well. A good trial lawyer is one who manages to get jurors to forget how miserable they are with having to serve on the jury, frankly. And Judge Jolly is shaking his head back there. An excellent trial lawyer is one who manages to get jurors to want to be on the jury and to want to stay and see how the case comes out. And that's your challenge. In addition to your honesty and your integrity, you bring to the courtroom two things that, in my opinion, are not negotiable. One is your credibility, and the other is your reputation. Far too many lawyers take on the persona of their clients. If your client's a jerk, then you're a jerk. If your client's a nice guy or a good guy or gal, then you may be. But when you take on that persona, you get kind of a schizophrenic reputation, because one week you're a jerk, and the next week you're somebody else. And as judges, we can't figure out which lawyer is going to show up next week for the calendar call. I think you need to separate yourself as best you can from the client. I think the most successful trial lawyer is a trial lawyer that's one in which it can be said that he's the toughest lawyer you ever faced, and yet at the same time, he or she is the nicest person you've ever met. If you can fit into that category, then you will, I think, be a worthy advocate. That's your challenge. If you have to take an absurd position on behalf of your client, I think you should say, "It's my client's position today, Your Honor. It's my client's contention today, Your Honor," because we frequently forget the foolishness and the absurdities of clients and the absurd positions that they take. It's harder to forget the absurd position that the lawyer takes. I suggest that you not negotiate with a jury. If your case is worth $10,000, don't ask them for $200,000. They just simply stop listening. Do not make promises to the jury you cannot keep. The most memorable one is the Percy Mormon case, in which I was involved with years and years ago, which Mr. Mormon was accused of raping. He was the quarterback at state, and he was accused of raping a co-ed over there. Jury Paul represented him, and jury's opening statement to the jury was that he was going to prove that Mr. Mormon was physically incapable of committing rape, committing sexual intercourse with the victim. Of course, Percy knew that he was, because he had committed the act, and he didn't have a clue what his lawyer was talking about. And he offered no evidence to show physical incapacity, and his client got convicted. So you need to be accommodating as best you can in your dealing with a jury or jury selection, and be careful how you act around the jury. You need to talk less and say more. Frankly, you need to put your thoughts together before you speak. If it takes a minute, you need to ask the court, "Could I have a minute?" rather than ramble on for 5 minutes while you're trying to come up with a really good idea in answering a question. If you don't know, for heaven's sake, say, "I don't know, but I will find out." I will find out and get right back to you. Work on trying to not get on the bad side of the judge. Don't fight about everything. If you fight about everything, we don't know what's important and what's not. Avoid putting the jury in a position of having to decide who's telling the truth if you can. Jurors would like to believe everybody. And so if it's possible that you can, in a case, take the position that the witness is simply mistaken, jurors buy into that a lot quicker than the witness is lying. If your evidence is consistent with a witness, assume some things that caused him or her to reach the wrong conclusion, honestly. That sells better than just simply confronting the witness and accusing the witness of lying or suggesting to the jury that they are. If you're trying paper cases, obviously, when the witness is looking at the will and reciting it, the jurors need to have a copy of that will in front of them, or the contract, or the lease, or the letter. Otherwise, they are clueless as to what that conversation with the lawyer and the witness is about. Remember, there is a morning after, and there is another case. This is not your only client. This is not your only case. Do not burn bridges that will affect future clients for a long time. Don't compromise your reputation. Don't compromise your credibility for any client or any case. Obviously, don't knowingly make any kind of false statement to the court. That is a really difficult thing for a judge to ever get out of his or her mind for a very, very long time. Try the case that you've got, not the one that you wish you had. It is incredible. I mean, if you start your opening statement by saying, "April the 8th of 2004 will live in infamy," in the life of Alice Smith, then Alice had better be a quadriplegic, or hopefully she didn't get hit from the rear in her car with soft tissue injury and lost no time from work. Try the case you've got, not the one you wish you had. Remember that also that incivility begets incivility. It's awfully tempting when you've got a jerk on one side to jerk back. By the time that we see it, it doesn't really matter when you say, he hit me first. All we know is we've got a fight that's a mess. And so you get caught up in it and you get responsible for it too. Incivility begets incivility. Don't get sucked into that kind of a lawsuit. You can be a face-to-face lawyer without being an in-your-face lawyer. It's a matter of attitude and self-discipline. Also, remember that it ain't over till it's over. And so I was had a motion for summary judgment over in 10B, probably 10 years ago. And the plaintiff's lawyer had lost the motion. It was a commercial litigation case, an unfair deceptive trade practice claim. I allowed the motion for the defendant on summary judgment and dismissed the case, and the lawyer slammed his books together and stormed out of the courtroom. And the bailiff gave me that look like, let me put my hands on him, Judge. And I said, oh no, that's okay, let him go. And then after he closed the door, I said to the defendant's lawyer, do you wish to be heard on cost and attorney's fees? Remember, it's not over until it's over. I've got this opinion I found a long time ago. It's out of California, and it's written by an appellate court. It's a 1974 opinion. It just sort of describes lawyers, and I'll read it to you, and you can tell me or tell yourself which of these kind of lawyers you are. Hopefully we'll all strive to be one type and not the other, and I'll read a part of it. It says this: there are incompetent lawyers just as there are stupid judges, quack doctors, and inept plumbers. We observe that while trial lawyers come in all shapes and sizes, and no two trial lawyers are identical in style, they fall generally into two categories. The first category files every conceivable motion and presents issues ad nauseum. This attorney slows down the wheels of the administration of justice, exasperates trial judges, and bores and often succeeds in confusing juries. He does everything by the book, and his win-loss ratio usually leaves much to be desired. On appeal, it must be conceded that he has made a good record. No stone has been left unturned. Of course, he lost the case, but he has made a dandy record. The second category of trial attorneys is usually much more effective. He has the capacity to reduce issues to simple terms. He is miserly with motions, objections, and issues, as Ernest Hemingway with words or Louis Armstrong with musical notes. He has an instinct for the juggler, an ability to explore the meritorious and ignore the trivial, a capacity for keeping issues understandable, a high respect for the intelligence of the jury, and by reason of all this is usually as effective an attorney as the first category is ineffective. Of course, to the nitpicker, his record on appeal leaves much to be desired, since he has not pressed every motion or made every possible objection, nor has he presented issues which, in his professional judgment, were a waste of time. I would hope that we will all strive to be that second kind of lawyer. I told Ripley that, and I'm through, I told Ripley that I pulled out an old page from the Litigator, which is the publication of the litigation section of the Bar Association, dated 1990. And Don Cowan listed the 25 things that the view from the bench in Greensboro in February of 1990 with Judge Jim Long, Judge Tom C., Judge Tom Ross, and Judge Harvey Lupton, none of whom are active judges today, discussed. And the issues that they discussed in 1990 are the same issues that are listed today for this program. Thanks for the opportunity to talk to you.
In order for you to get credit, Judge Stevens, you have to stay here for the next 38 minutes. Your responsibilities are not over. The 10 things that are listed on your lengthy manuscript are the 10 things that Judge Manning and Judge Fox and I came up with from reviewing several different presentations, and due to the circumstances, I'll let Judge Fox take the first one.
Good afternoon. One of the things I will say, I've been probably, I guess, in 12 counties in my short tenure as a judge, and I will say this: I have never been impressed, as impressed as I am in Wake County, with lawyers covering for other lawyers when they cannot appear in court. I have almost any time someone has not answered the call of the calendar, it is an attorney who is not from this bar. And I think it is a tremendously impressive thing that there's obviously the camaraderie and fellowship in this bar that allows people to feel comfortable to ask other people to answer the calendar if you cannot be there. And that's all I really want to say with regard to that issue.
I'll speak from personal experiences to that issue with respect to the way that my life works. If I plan to be somewhere early, I will get there early. If I plan to be somewhere on time, I will be somewhere between 15 and 30 minutes late without fail. If you can't be early to court, at least be on time. If you're on time, that's fine, but if you get to be there a little early, you get to know the clerks and the court reporters, the courthouse staff, and other lawyers, and you get to know a little bit about what goes on in the courthouse. Good lawyers will tell you that this is crucial, that you get to see other lawyers at work, to see what kind of presentations people make and what kind of things are effective. And when you get to know the clerks and you get to know the court reporters and things like that, when you need to get bailed out at some point, those will be the people who will help you. If you do not know who they are, they will not help you. Number two, and first off, I guess preliminarily, all these things seem like common sense. The fact that they're all written on essentially one line or maybe two lines, they're all sort of basic things. But if you spend enough time in a courtroom, you will see that only every once in a while do you see lawyers do all of these things. And so while it is common sense, if you think everybody already does all this, you're wrong. Number two, always introduce yourself to the court even if you know that the judge knows who you are. This is because it is important for you to know that there is more than one audience in the courtroom when you're before a judge. You also are before a clerk. The clerk has to keep the minutes of everything that goes on in the courtroom. If the clerk doesn't know who you are, the file may get lost, the ruling of the court may not get recorded, and things of that nature. The court reporter also needs to know who you are. How many of you have been yelled at by a court reporter who did not know who you were when you stood up to make your argument? Be truthful, raise your hand. More than 3 people in this room have been yelled at by, I have been yelled at by a court reporter who didn't know who I was. The jury needs to know who you are when you make your arguments because you want them to think about you as a named person and to invest in the types of things that you say. And from just a basic standpoint, the judges get upset when the record is hard to put together, when there are 3 or 4 lawyers in the courtroom and the court reporter doesn't know who's making an argument and what's going on. That makes things difficult for the court reporter, which makes things difficult for us. Number 3, Judge Stevens.
Let me go back to number 1. Okay. I mean, I'm always late, so I can't speak with any authority or credibility on that issue. But, folks, judges have a way of making a point, And so, if you're late a couple of times, the judge may open court at 9:30, put the jury in the box, and sit there. And when you come in at 10 minutes till 10, the juror's been sitting there waiting for you. It does a great disservice for your client. It may affect the outcome of your trial. The judge hadn't done anything wrong, but that may decide your fate in your case. So you just need to understand being late can have a significant impact on how a multi-million-dollar case gets resolved or a $3,000 case gets resolved. You may not, I have the luxury of being late, I admit that. You don't, and it's as simple as that. Okay, what is number 3?
Number 3 is know the rules.
Know the rules. I think what you need to do is you need to know the rules. Also, you need to know how to use the rules to help you. If you've got somebody that shows up consistently 30 minutes late for a deposition, or an hour late for a deposition, or brings groceries and eats during the deposition, or a lawyer who curses during the deposition, I mean, you'll find something in the rule that can help you against that kind of lawyer. If it's a motion for a protective order, to ask one of us to enter an order that says to the other lawyer, be on time, don't bring groceries, don't curse. But if you don't ask, we won't do it, and you'll sit there and suffer through it. There's a rule to solve every problem you've got with another lawyer if you look for it. And so the rules are your friend. You need to know them.
Judge Fox.
I think it's just as important as knowing the rules, it's knowing when not to use them to beat your opponent over the head with them. And when I was a prosecutor, I tried a lot of cases where I tried them against lawyers who were not nearly as skilled, and if you object every time you can't object just because you can, it gets old. I mean, it holds up the proceedings, and a lot of times people object to stuff that has nothing to do with anything, and everybody in court wants the case resolved and wants to be out of court, and anything that you can do to facilitate that helps. I remember one time I was trying a case with a lawyer who shall remain nameless in this courtroom, and the opposing counsel handed a witness about that many documents of tax records and said, "What is that?" And the witness said, "It appears to be a federal income tax form for the year 2001. Move its submission." I said, "Move its submission?" I looked at the attorney didn't say anything, goodness of his heart, and I looked at her and I said, "Whose is it?" "Oh, it's mine." And then she was handed a stack of medical records, twice that, same kind of thing. We would have never finished that trial if the attorney had objected to everything that he could have objected to, but graciously enough, he throttled back, and the verdict ended up showing that it was highly in his favor given the offer that was made. So, being nice and not using everything to your advantage helps you as much as using all the rules against someone hurts you.
Judge Manning made a specific point to me when he told me that he had double calendared himself for today. I believe he said that somebody else had double calendared him for today, so it was one of those types of things. That he wanted me to mention Rule 12 of the General Rules of Practice. The General Rules of Practice, the only place that I've ever seen them located are in the Annotated Rules book, which is the big thick book that I never looked in when I was at the DA's office. And so a lot of this came as a surprise when people like Judge Stevens informed me that I had violated one of these rules. But the bottom of Rule 12 indicates that counsel should yield gracefully to rulings of the court and avoid detrimental remarks both in court and out. Judge Manning would have you know that Rule 12 is one of his favorite rules, and that he cites it probably once a week in court to somebody. And having been on the receiving end of that on at least one occasion, I can vouch for his credibility as to that matter. And so I would just remind you, especially with respect to Judge Manning, as to Rule 12. Number 4 is to do the little things that make a big difference. Pre-mark your exhibits. Make copies of cases that you want to present for everybody to have. Make copies of exhibits to give to the jury so the jury doesn't sit there for an hour as a 10-page document gets handed from person to person to person to person. As Judge Stevens said at the beginning, while we all hate to have our time wasted, the jury really hates to have their time wasted. And so to have a document that they have to look at and pass through without copies having been made beforehand, they view as being a waste of their time. And so the little things like that make a huge difference, both to the flow of your case and to the clerks and court reporters who don't have to help you mark all your exhibits and keep everything organized for you. Because while we rotate out and you may never see some of us again when we go to a different county and things like that, the clerks and the court reporters will remember you the next time you come to court, when you spent 3 days making them miserable, making them mark all the exhibits, making them make copies for you and doing all your work for you. And of all the people that I don't want to have mad at me, the clerks and the court reporters at the top of that list. Anything to add? Number 5, and this particularly applies to me, assume the judge and or the jury has no idea what your case is about when you walk into the courtroom on Monday morning. The phrase that I have found to be sort of the most difficult in dealing with is, as Your Honor clearly understands and knows. And I'm like, look, don't do that. Don't put that in the record, because that's just going to reflect badly on me if I get it wrong later on. Assume the judge does not understand or know what your case is about. A brief discussion of the facts and procedural posture is always helpful, especially on a day like next door in 10D, where the judge has been dealing with 50 motions and has 50 others pending at the end of the week. It also helps to do homework on knowing what the judges like. Do the judges like to have written briefs? Do the judges like cases instead? Judge Fox.
Particularly with juries, if you ask a question and the answer that the juror gives you appears to be something that's going to be bad, assume it's going to be bad, and don't ask a follow-up question. The other day someone asked a juror, have you ever had a bad experience with court? One juror raised his hand. What was it? Well, that's like that. You ever seen that email that's going around where they ask the juror what she thought of the prosecutor, and she goes down and tells this horrible story? What do you think about the defense attorney? And he says, if the judge says, if you ask her about me, I'm going to hold you in contempt. And so he asks, well, what was the bad experience? Well, I was in for DWI, and I couldn't get my community service done. They had me arrested. I tried to get it resolved. They made me hire an attorney and spend $700, and finally I got my community service done. That was my bad experience. Everybody looks at him, looks at the prosecutor and says, you want to ask anything else? I'm thinking, why'd you ask it to begin with? And this happens quite a bit. In one case, we were asked, we had a lawyer in civil cases. This should never happen in, because you have an opportunity to know what those people are going to testify to. Lawyer asked the witness, has your life been affected by your wife's injury? This is a loss of consortium claim. Well, yes. She can't mow the grass, and she loved to mow the grass. She can't cut the shrubbery like she used to. She can't vacuum. Do you vacuum as well as she does? No, I don't. She can't make the bed. She can't do the dishes. She can't cook. Do you do the dishes as well? No, she does. And the lawyer never looked over, and a lot of lawyers are guilty of this, never looks at the jury to see what their reaction is. well, there have to be 8 women on this jury. And they were all doing this. Well, your case is pretty much over. You can't get them to change that post. But, you know, I think that while you have to assume people have no idea, you have to adapt to what's happening in the courtroom and not do anything that causes you irreparable harm. And that's being sensitive to what's going on with the jurors and paying attention to them.
When my wife was in private practice, and either she or somebody in the firm had a hearing in front of some judge, and in Caldwell County or somewhere, and she'd always say, "Do you know Judge X? We got a hearing next week, and tell me about it, him or her." And we'd always get around to the brief, and I'd say, "How long is it?" And she'd say, 50 pages. I'd say, "He won't read it." You need to know your judge. You got judges who'll read a 50-page brief. You got judges who'll read a 2-page brief. If you got a 50-page brief, judge, that's fine. You got a 2-page brief, judge, your brief needs to be 2 pages. If you can't do that, put on the top of it, executive summary. 2 pages, you summarize your 50-page brief. I mean, this is the practical practice of law. And that's just one of those, that's one of those things when you be able to, what do you know? I mean, how much does a judge know? I mean, we hear so many matters and so many cases and so many motions. I mean, I may rule on summary judgment or Ripley may, in a case that comes back in front of us a year and a half later, and somehow or another, lawyers will expect us to know where we stopped off at that last hearing. We can't even remember who the lawyers are, who the parties are. Probably can't even remember how we ruled. So you just got to begin from the beginning all over again, in fairness to your client, in fairness to us. Frequently, if I've got 12 lawyers out there in a 30-minute motion or an hour motion, the first 10 minutes I spend diagramming who all the lawyers are and who the parties are. So I can even figure out what the playing field is. Okay? And then if you've got a summary judgment motion, you jump off into your summary judgment motion as if I know everything that you know about the case. And that, it's really, I would like to think that I do, and I hate to stop you and tell you I don't have a clue about this case. But you're better off if you assume that we don't know. And then help us from the beginning. Start from the beginning. Keep it simple. Executive summaries are good. 2 pages are great.
Number 6, plan on your technology to fail you when you think you need it the most. This goes from your PowerPoint presentation to your Trio, dry erase markers, whatever it is, whatever kind of technology you have involved in your case, you need to be sure that you're able to present what you need to present either to the judge or the jury without it. If you get on the elevator and somebody backs into you and breaks your hardboard presentation in half that you had getting ready to give, or it rains and all the ink runs off of it, you need to be able to do with a pad and paper and pencil the same thing that you would do with $35,000 worth of plasma TVs and 3 computers running at the same time like we had in the case a while back. And the legal assistant who did that was unbelievable. I've never seen anything like that in my life. Literally 3 different computers running all at the same time, running this closing argument with a big TV in front of it. If it had gone wrong, I would not have been able to sit in the courtroom and watch it because it would have been painful to see. So plan on your technology to get you at the very opportunity that you need it the most.
You need to say to yourself, I am a lawyer. I am not an IT person. You need to bring your IT person with you, frankly. That way you don't have to worry about that presentation. If you're going to do both, your lawyering will suffer.
And even when you have your IT person, sometimes it still screws up. In a trial just recently with Judge Manning, they had all this technology in there, and they couldn't get the subtitles to synchronize with the video. Why they needed subtitles, it was all in English, I don't know, but they were playing all this stuff. And I know it looks good, but when it screws up, nobody wants to wait for it to all get reconciled. So it all has to go forward some way.
Number 7, be able to distill your case into one sentence without semicolons anytime you're being heard in court. I am a ritual abuser of the semicolon, and so I have trouble with this myself. But whenever you are in court, you need to be ready to tell the judge or the jury or whoever it is in one sentence what your case is about. What is this about? If you can't distill your case into one sentence, you're not organized enough to be able to know what you need to prove with respect to jury instructions. You won't have a theme that starts during jury selection and goes opening statement, evidence, closing, jury instructions. You need to be able to knock it down into one sentence, because a lot of times that may be the only, when the judge says, well, what is this about? What's going on? That's your opportunity, and if you start a 15-minute explanation, it ain't going to go well.
Well, the first thing the judge is going to say in chambers, if he gets lawyers together, is, what's this case about? He's going to say to the plaintiff, what's this case about? Plaintiff's lawyer, say to the defense lawyer, did you bring your checkbook? You know, and you need to be able to say, you know, in a couple of sentences, what the case is about. There is a appellate opinion on the books in a case that Judge Russo tried in Wilkes County, in which our appellate courts has said 5 minutes is a reasonable period of time for an opening statement. A trial judge may tell you, you have 5 minutes to tell this jury what your case is about. You need to have the ability in 5 minutes to tell this jury what your case is about so they'll understand it. So you got to be able to refine it, no matter if it's you value it at $2 million or it's valued at $2,000. That's just a basic principle of good lawyering.
Similarly, nothing could be worse than failing to respond to a question on point. I can tell you, I loathe people starting out the answer to a question, well, let me just say. No, how about let's just answer? I actually had an attorney one time, when I was asking this attorney a question, hold up the hand and say, stop. Needless to say, I was stunned, and I simply said, last time I checked, I asked the questions, you answered the questions. And I think that there's nothing worse. I mean, you expect that from people who are unrepresented, because they want to tell you something, and you know, they're really not listening to what you're asking them. Lawyers, it should be different, and I think that a lot of judges just stop listening when you start answering something that hasn't been asked. There's nothing better to me than on-point answers and direct answers to direct questions.
I think the more important question here is, that's the kind of thing that when you ask a question and the lawyer says, well, I think the more important question here is. No. Number 8, how is this going to look to the judge? Whenever you're in a dispute with the other side, whether it's in court or out of court, before you go off on somebody, think, how is this going to look to the judge? The judge is going to find out about it one way or the other, whether the judge is sitting there or not. This is also known as the don't be a jerk rule. And Judge Stevens has already spoken in detail about that. Judges tend to look for who is wearing the halo whenever there is a bitter dispute about something. And when it appears that there is no halo to be found, both sides will likely be unhappy with the ruling.
Good manners is always good lawyering. You just can't say it enough. You know, there's just nothing that can beat good manners. Winning, but still respecting the other side, losing gracefully and dignified, treating each other the way you would expect to be treated. There's just no substitute for that. And remember, it's not just about today. It's about the rest of your practice and every client you represent in the future. What you do today may well impact that for a long time.
It's horrible when a party is argued and the other party gets its turn, and every other word the party says, someone objects or someone interrupts them. I've seen lawyers literally stand up when the other party's talking, like no one will notice they're in the room to call on them again if they wish to respond. And it's rude. And similarly, when people deteriorate and start arguing and addressing their arguments to their opposing counsel rather than the court, you just sort of stop and think, where is this going to go? Are they going to go out and fight in the parking lot when this is all over with? And I don't think there's any substitute in anyone's mind, a jury or a judge's, about professionalism. And professionalism means being nice and showing good manners.
Number 9, give the judge a heads up about things. If there is some bizarre fact that is disputed in your case, or something weird about your case that you haven't encountered before, I beg of you, please tell me, if nobody else. Tell me about that before the case gets started. There are probably 3 or 4 instances in the last year where it was like somebody had fired a gun in the courtroom during the course of a case when something I had no idea was coming, that the other lawyer had no idea was coming, and the jury certainly didn't have any idea was coming, just sort of sprung out into the courtroom sort of unprompted. We want to know stuff like that. You know, if it's something that that's going to present a problem that you can't go back and unscramble the egg after it gets put out there, that's something we want to know about. Apparently, something I want to know about.
Always do.
I like surprises.
Well, for the judge, a surprise is a challenge, and we like to minimize our challenges.
With respect to evidentiary issues, if you know you're headed down a path when there's going to be a lengthy evidentiary hearing on something, make the judge aware of it beforehand. So, you know, you can let the jury go to take an early lunch. You can let them go home early or tell them to come back late the next day. The jurors spend all their time when they're locked back there in the room trying to figure out what's going on in the courtroom and who's to blame for making them sit back there. Sometimes it's the judge that ends up being the one to blame, and I've had to deal with that a couple times, but oftentimes they have figured out whoever the lawyer is that's making them sit back there, and that will cause you problems later on. It makes things nicer for the jury to be able to leave early. They're a big fan of everybody when the judge says, you know, the lawyers and I have talked about it, and we're all going to let you go home at 3:30 today to come back tomorrow. Everybody wins when something like that happens, and nobody wins when the jury has to sit back there for an hour. Number 10, I can speak to this personally, and I remember it like it was earlier this morning, sitting in on a hearing down in courtroom 3A with the Honorable Donald W. Stevens presiding in a bond hearing involving a defendant charged with, I think it was some sort of felony assault. And I stood up and waxed eloquent for several minutes about the defendant's horrible criminal record and the devastating injury to the victim, and then sat down, and Judge Stevens sat there for a minute, and he pulled his glasses down at the end of his nose, and he said, "Mr. Rand, what do you want me to do?" And I sort of stood there for a minute, and I finally said, how about you just leave it like it is? You know, just don't hurt me. Tell us what you want us to do. I mean, it is kind of frightening how often the lawyer will stand up and talk and talk and talk, and in the end, you're like, well, what am I supposed to do? And the juries give the same look. What do y'all want me to do? Dave Barry wrote a column several years ago about these BASF commercials where they have like the waterfall and the car driving down the road, and it says BASF, we make technology better. And his response was, what do you want me to buy? What is this about? What do I do with this information? Tell us what you want us to do.
Sounds good to me.
Shannon, what do you want us to do?
I would like to offer them.
Could I
Well, yes.
make one other?
Sure.
I've listened to
I wanted to talk about jurors for just a minute. I mean, you need to understand that trial judges are really protective of jurors because jurors look to them to sort of control how they're treated. Lawyers sometimes think you can ask a juror anything you want to during jury selection. Questions you could not even ask a witness on the witness stand adversely, you can ask a juror. What's your medical condition? How many times have you been to the hospital? Are you taking medication? You know, how long have you had this job? Why did you lose it? I mean, it is incredible all the kinds of questions that folks picking a jury thinks they're entitled to ask the juror. And so we're very protective of exactly what we're going to let you ask jurors. And I got a little thing I wrote out here that I'll tell you if I can find it. I was picking a jury in Vance County a long time ago, back when Johnny Edwards was trying lawsuits and getting big verdicts, and there was this young lawyer who well, to begin with, any question you ask a juror that begins with, how do you feel? Okay, judges' ears go up. How do you feel? You know, how do you feel about $50 million? How do you feel about homosexuals? How do you feel about mixed marriages? I mean, that presupposes that the juror has some feeling about that subject to start with. So I'm in Vance County, and the young lawyer says, basically says, how do you feel about people who bring lawsuits? Objection sustained. That presupposes the juror has a feeling about that. Of course, you could have rephrased and said, you know, do you have any feelings about people who bring lawsuits that may influence how you view this case or your decision? But the same question was asked again and again and again. Objection sustained, sustained, sustained. So the young lawyer said, can I approach the bench? And I said, sure, come on up. And he said, Judge, he said, I just went to a seminar and Johnny Edwards spoke at the seminar to tell us how to pick a jury. And Johnny said, first you ask juror number 1 how she feels about people who bring lawsuits. And then you ask juror number 6 to comment on what juror number 1 said about people who bring lawsuits. And I believe that this is entirely proper, and I don't understand. I don't understand. Why did you sustain my objection? So we're at the bench, and I said, can I let my blood pressure go down just a little bit, you know, having to explain why I sustained the objection to a question that was improper but could have been properly asked. And so I said, young man, you're not Johnny Edwards. Okay? We're not in the Superior Court of Wake County trying a case involving a quadriplegic or a multi-million-dollar wrongful death case. We're in the Superior Court of Vance County. We're trying a slip and fall at the Winn-Dixie with medical bills of $500, two trips to the chiropractor, and a lady who did not lose work. Okay? The objection is sustained. You need to understand, too, that what you're trying sometimes has a big impact on what we as trial judges allow. We allow you greater latitude when the stakes are high than we do when they're not. And so what we may allow today in one case may be a little different than what we allow tomorrow. And so you need to keep that in mind, and it's not just a simple decision, especially when it deals with jurors. Also, you're about to run out of time. Be careful about what your clients do in the presence of jurors. Jurors watch you all the time, watch your clients all the time. The securities case over here about 8 or 9 years ago, in which the defendant called a witness who came into the courtroom and testified, and then we took a break. Defendant came outside, jurors standing around, had a conversation with the witness, pulled out his checkbook, wrote the witness a check, handed it to him, he got on the elevator and left. Okay? We go back in. One of the jurors sort of reports that to the bailiff. The bailiff brings it to my attention. Defense lawyer for this client is concerned. Okay. Brings it to my attention. I asked the plaintiff's lawyer, need a hearing? He said no. I don't want to hear. I don't need a hearing. Why would I want to hear? Defendant's lawyer, why are you entitled to a hearing? A hearing on what? On something your client just did in the presence of jurors that may have prejudiced him? You want to call him back around, let him explain that, the jury, fine. What am I having a hearing on? Okay, so, didn't have a hearing. He called his client back. Client said, this is an old friend that, and his daughter's getting married, and I was so happy, I wrote him a check and gave it to him and said, I hope they do well. And the jurors, and that was probably true, but the jurors were sitting there going, yeah. Yeah. You need to be really careful what your clients do in the presence of the jury. No, I'm through.
Quickly, if I lost a consortium claim, your case is over with if the wife sits on one end of the pew and the husband sits on the other. It really is important that you pay attention to that. And one of the best closing arguments I heard so far, a lawyer stood up and said, how much do you think it's worth to have to push a tube? This guy had to catheterize himself after a car accident. To have to push this tube into yourself, past your sphincter, into your bladder, and drain yourself, and then feel like you still had to go 3 times a day for the rest of his life, which is calculated based upon these tables to be 51,900 some odd times. And I was sitting on the bench, not involved in the case, and I'm thinking I wouldn't do that for $100 a time voluntarily. And the jury ended up coming back with an award. It was 3 times the offer after that argument. So your ability to relate what it is you want clearly and concisely, and particularly if you can relate to something painful and excruciating that they don't want to go through, does make a difference.
Questions? The question was, how do you give somebody a heads up when you know there's something bizarre about your case? When there's something bizarre about the case, just ask, just get the other side and ask to approach, and either go back in chambers to talk about it or talk about it at the bench off the record before you get started. Just, I mean, it usually doesn't take more than a couple minutes. Just say, we need to kind of give a heads up about this. Let's go up there and tell him about, the knife we found in the parking lot or whatever.
I do want to thank these judges for being here. I think it was a great program.